Dictation will start after 5 seconds. Start. Mr. Raichaudhuri, in the case of Basiraj and ANR dot within bracket Supra, comma, Mr. Ghosh urged that the words sufficient cause in section 5 of the Limitation Act and sub-rule within bracket 5 of Rule 4 of Order XXI of the Code means that the party should not have acted in negligent manner, comma, there was no want of bona fide on its part in view of the facts of the case and there was no lack of diligence of the party. Stop. Para. The next contention of Mr. Ghosh was that the respondent number 5 resided at a portion of the suit premises where she died and the appellant running his shop in a portion of the suit premises was all along aware of the death of the respondent number 5 in May 2008, as also the particulars of the legal representatives of the deceased respondent number 5. Stop. The residence of the respondent number 3 is opposite to the residence of the appellant and the appellant was also aware of the death of the respondent number 3 in April 2012 and the particulars of the legal representatives of the respondent number 3. Stop. These facts stated in paragraph 4 of the application of the defendant respondent number 1 could not be disputed by the plaintiff appellant in his affidavit in opposition filed in CAN 1238 of 2014. Stop. Thus, according to Mr. Ghosh, it is absolutely untrue on the part of the appellant to allege that he came to know the death of the respondent number 3 and 5, for the first time, after receipt of the said letter dated March 22, 2013 from the advocate of the respondent number 1. Stop. According to Mr. Ghosh, once the appellant came to know the death of the defendant respondent numbers 3 and 5, in May 2008 and April 2012, he made no inquiry whether other respondents in the appeal are alive or not. Stop. He submitted that if the appellant would have made any inquiry, he would have also known the death of the respondent number 2 in March 2012. Stop. In any event, the respondent number 4 died in 1989 during pendency of the appeal before the learned First Appellate Court, and there is no question of abatement of the appeal against the respondent number 4, since deceased. Mr. Ghosh urged that the appellant's application both for condonation of delay and for setting aside the abatement of the appeal is lacks bona fide and the same is liable to be dismissed. Para. Mr. Ghosh further submitted that the second appeal has been filed by the appellant/plaintiff against the judgment and decree of the learned First Appellate Court affirming the decision of the learned trial court that the suit premises was the family dwelling house and allowing the claim of the defendant respondent number 1 for preemption in respect portions of the suit premises against both the stranger purchasers, being the plaintiff/appellant and the defendant respondent number 3. Stop. This decision of the learned First Appellate Court that the suit property is the family dwelling house and the consequent decree for preemption in favor of the defendant respondent number 1 against the plaintiff appellant and the defendant respondent number 3, since deceased cannot be interfered with by this court in second appeal, as the same decision has become final as against the legal heirs of the deceased respondent number 3 on the ground of abatement of the appeal against the said deceased respondent number 3. Stop. Thus, he contended that in view of abatement of the appeal as against the deceased respondent number 3, the entire second appeal is bound to fail. Stop. In support of such contention, stop.